All right. Hello, everyone. Thank you all for coming to our webinar. I hope everyone's having a good day so far. Let's see, we'll give everyone maybe like a couple more minutes to trickle in, but we're really excited to be speaking about trademark and copyright today. Let's see. Yeah, it's exciting to see familiar names. Cool. All right. Let's let's go ahead and get started. Nina, Caitlin, is that good with you guys?
Mhm. Yep.
Okay, cool. All right. Okay, so trademark or copyright? You must be wondering, this is the burning question. What are they? And what do they protect? What are they? That's what we're here to discuss. And yeah, we're excited. So for housekeeping, to quickly go over some rules or expectations, we will have a Q&A at the end of this presentation, so feel free to submit your questions using the Q&A function that should be down below. Um, One of us will be answering the questions live, or maybe you'll just get an answer right then and there on the QA function, but feel free to use it. At the end of the webinar, everyone will be receiving a link to the recording and the PowerPoint presentation. So if you need to leave early or if you're coming in late, don't worry about it. You will receive a recording. Um, Introductions. Look at these lovely faces. So starting with Nina Amiri. She is the founder and principal of Amiri Law PC. She is a well-known and respected attorney with over 20 years of experience practicing law. Opening her own law firm back in 2019, Nina has dedicated her practice to making sure creatives are protected as they embark on their journeys within the entertainment industry. Whether it is through conducting trademark audits or helping clients build their entire intellectual property portfolio, she offers clear, actionable guidance to ensure that creators are empowered to protect and monetize their intellectual property. Next is Caitlin Bradshaw, an associate at Amiri Law PC. Having grown up in a family with a deep passion for music and art, Caitlin developed her own passion in helping creatives and artists protect their rights to their works and their respective brands. It was this experience that led her to law school to become an entertainment attorney. And since starting at Amiri Law as a law clerk in 2022, then an associate in 2024, Caitlin has been able to gain wide-ranging experience with respect to our intellectual property practice, from applying for and maintaining trademark registrations to drafting and sending cease and desist letters to protect our clients' rights. Last and hopefully not least is me, Kylan Nguyen. I am also an associate at Amiri Law PC, with a passion for entertainment born from my own love of art, literature, music, theater, etc. As someone who's creative myself, or at least I like to think I am, I understand how important it is to protect your work and your brand, especially now that we have the internet and just so many social media platforms. That's why I'm especially passionate about empowering creatives to take the steps that they need to protect their brand and build a strong foundation for their business. So why are we here? Nina, I think you're the best to handle this slide.
Thanks, Kyla. Gosh, how many times have I been asked, what's the difference between a copyright and a trademark? And, I usually explain it and I try to give real life examples. But it's still confusing. We deal with this stuff every single day, but for the average creator, the average business owner, this is, a kind of confusing area of law. And we thought that rather than doing two separate webinars, we really should kind of talk about copyright and trademark side by side, so that our clients, friends of the firm, our audience on YouTube could get a clear picture, of what these two, very different types of IP are. So, the reality is that as a creator, entrepreneur, business owner, when you don't file trademarks and copyrights, it can be very costly for your business, for your brand. Your brand can get hijacked, your work can be copied, other people will try to monetize your work. And so it's really a drain on your time and your resources when you don't properly protect your IP. It's one of the things that I really try to convey to people, that at the very beginning, when you are just starting your business, your brand, your channel, protect your content. You're going to be collaborating with other people. It needs to be clear who owns the IP. Um, I want you guys to think about trademark and copyrights not just as a formality, but think of them as strategic tools, that you have, because when you use them effectively, you can safeguard your brand. You can prevent other people from using your brand. And so the point of this webinar is we're going to show you ways that you can leverage trademark and copyright. We're going to kind of simplify, what the registration process is. And hopefully at the end of this webinar, you're going to be kind of in a better position to take the next step to start protecting your trademarks and copyright. So I'm going to hand it off to my amazing associates who, are working on these matters every day.
Thank you, Nina. So like she mentioned, we'll be talking or we'll be discussing both copyrights and trademarks. But I actually first wanted to ask all the attendees, and feel free to, I think you can comment. Yeah. What do you think is the difference between a trademark and a copyright? Um, if you have any thoughts, feel free to put them down. You can also just put, I have no idea. That's why I'm here. But I kind of wanted to see like what you all think, what the difference is, or maybe you don't think there's a difference. Okay, we have a not sure from Lauren. Hi, Lauren. Thank you. Lauren is my friend. And also, good answer. That's why we're here.
Don't be shy. It's okay if you don't know the difference.
For a logo, copyright USPTO protection for a work of art. Okay, cool, cool. Good answer. They're all going to be good answers. Also not sure. Also good answer. Um, okay, cool. So you'll learn more as you listen. But first, we'll start with copyright. So, what is a copyright? A copyright, well, copyrights protect original works of authorship, specifically those that are fixed in a tangible medium of expression. Um, when someone has a copyright, it gives the creator, the author of the copyright, exclusive rights, meaning only they can do the following: reproduce the work, create derivative works, distribute copies of the work, perform the work publicly if it's something that can be performed, or display the work publicly. Those are the rights that are afforded to a copyright owner or the author of a copyright. But what is a copyright exactly? So, contrary to popular belief, a copyright actually automatically arises the moment the work is fixed in a tangible medium of expression. So you don't actually need to obtain a copyright registration to be like, hi, hello, I have a copyright. As soon as you put pen to paper and you like draw something or you write something, a copyright has arisen. So you might be asking yourself, well, why, if I already have a copyright, why in the world would I go through the steps of registering a copyright with the US Copyright Office? Well, the answer is in order for you to be able to sue anyone for infringement or bring anyone to court, you actually need a copyright registration from the USPT or the US Copyright Office. So, what can you copyright? Like I think someone mentioned in the chat, literary works. So written works, books, scripts, blogs, poems, articles. You can definitely copyright those. You can copyright musical works, the compositions, the like the notes, the guitar tablature if you have them, the lyrics, dramatic works, choreographic works, pictorial, graphic, and sculptural works. Motion pictures, absolutely. You can copyright movies and other like TV shows and YouTube shows. You can copyright sound recordings and architect. There's a lot that you can copyright so long as it is fixed in a tangible medium of expression. The question or the next question is, what can't you copyright? Because it seems so broad, right? Well, you can't copyright ideas. Meaning if you just kind of, stand in the park and you're like, you know what? I'm gonna make a story about a shark that terrorizes a beachside community, and then someone makes a movie about it, you can't be like, well, I had that idea first, so I'm gonna sue you for copyright infringement. You didn't fix it into a tangible medium of expression. You didn't write a script for it. It was just an idea that you had. You can't copyright ideas. You also can't copyright processes. That's more of like a patent thing. You can't copyright recipes because they're essentially a compilation of facts. Um, and like you can't copyright facts unless you have a creative way of compiling it, like if you, I don't know, added cute borders or started categorizing it differently. But you also can't copyright titles and slogans, but we'll talk more about those later. And you can't copyright works that are just not fixed in a tangible medium, whether it's because it's an unrecorded, improvised speech or something that is too transitory or too quick to actually be captured in a tangible form. All right. I know that was a lot of information, but it's also only been like 15 minutes, so hopefully everyone's still paying attention. And we have a pop quiz. Hold on, I will, lot of technical difficulties. All right, P1. Okay, pop quiz. Which of these can you copyright? A, an idea for a movie. B, the name of a book series. C, the lyrics to a song. And D, a product name.
Just so you know, we're not allowed to vote.
Although I will say there's been a lot of right answers so far. It's been 100% for one of the selections. Um, oh, we have some departures. I will give it like one more minute, one more second. All right. And poll, share results. So the answer was lyrics to a song. You can absolutely copyright lyrics to a song. It's a written work, fixed in a tangible medium. It meets the threshold of creativity. Idea, you can't really copyright. Names, you can't really copyright names either, but we'll definitely talk more of those or more about those when we discuss trademarks. All right. So you have a copyright. Cool. Great. What does owning a copyright actually do for you? What does it accomplish? So when a person or an entity owns a copyright, they are able to control how their work is copied, shared, performed, or adapted, and deter others from exploiting their works without permission or compensation. Um, so imagine someone that writes and records an original song. Once the songwriter registers a copyright for the song, if another artist tries to sell copies of that song without their permission, that songwriter, because they registered the work, has the ability to sue and stop them. But more about control, if they do choose to allow others to like exploit the song, distribute the song, perform the song, they control the terms in which permission is given. They can negotiate compensation, the parameters in which someone can use a song. They can control how their work is shared because they own the copyright. All of this ensures that a creator can benefit from their own creativity while protecting the integrity of that work. So, like I said, if a copyright exists upon creation, why register? And this is a question that clients ask us a lot once they learn, like, wait a minute, I've had a copyright in something all along. I'm set. Well, yes, you have a copyright, but you still should register. One, because it establishes ownership. So once you have a copyright registration, it becomes public record. And anyone that does their due diligence will look you up or look that work up to understand, okay, is this copyrighted? Who owns it? And if I want permission, who do I need to reach out to get that permission? So a copyright registration creates public record that you are the legal owner of the work and establishes proof of authorship. Um, it also helps you protect your creative work by strengthening your ability to stop others from copying. You can actually bring someone to court for copyright infringement if you have a registration. If you don't and you get embroiled into a lawsuit or something because you want to sue someone, you could expedite a copyright registration. I think it's like $900. It's several $100s that you could have avoided had you just had a registration earlier. Um, Also, lastly, having a copyright registration enhances the legal remedies that you could pursue. Basically, you can seek statutory damages, that is, damages prescribed by the copyright statute, and attorney's fees in court when you sue for infringement. Oftentimes, this is more. Well, actually, it depends, but it is a set amount that you can seek if maybe their infringement doesn't rise to that amount. Of course, if their infringement is egregious and just so bad, you could actually get more than statutory damages. But no matter what, this is your baseline. And it just makes enforcement more effective and less costly. All right, I'm going to quickly go over this because this is a lot, but this is the overview of the copyright registration process. You have your work. It's prepared, it's done. Um, you can, oh, it says 3. Anyways, you can complete the application on the US Copyrights online portal. And part of that is you're just providing details about the work, the title, the author, when you created it. Pay the filing fee. The filing fee depends on how many works you're submitting, what kind of work. And then you submit a copy of the work to the US Copyright Office. They typically require a copy for their internal records. It's called your deposit. And it's you just tell them this is the work that I am seeking to copyright. They take a look at it, make sure it's complete, and they usually give the stamp of approval and you receive the certificate of registration. In general, this process is a lot simpler and straightforward than, say, trademark applications. Um, but it is a process. And then wait times also vary too, depending on the time of year. But it's quite easy. All right, everyone's favorite. This is another pop quiz. Let's see. So which is not a benefit of registering a copyright? Oh, A, gives public notice that you are the copyright holder of a work. B, grants you the ability to sue someone for copyright infringement. C, formally grants to you a copyright in the work. And D, allows you to seek statutory damages in court in the case of infringement, which is not a benefit. I give everyone a second. There's 2 answers that are currently battling for the top right now. One of them is correct. One of them maybe not so much. All right. So, and pull. So it was tied between A and then B. So A, give us public notice that you are the copyright holder. That is a benefit. You are absolutely giving public notice because it's publicly recorded on the US Copyright Office's website. The non-benefit is C, it formally grants you a copyright in the work. If there's one thing that you will learn from this webinar today, please know that you have a copyright in the work as soon as you create the work. So you don't need a copyright registration to formally grant you anything. It's just a registration, but you have a copyright in a work
It's a
as
trick
soon as you make
question,
it.
guys, but
Yeah.
we want to, make sure you understand that right when you get that, whatever that work is, if it's a screenplay, once you put it in a tangible medium of expression, you've got a copyright. The problem is you don't get these other three things, and those are the things that you absolutely need.
All right. What's next? Oh, so that was the end of our copyright section. Good job, everyone. I hope you learned a lot. I will now kick it to Caitlin to talk about trademarks.
Hi, everybody. Switching over into trademarks. A trademark is essentially any word, name, symbol, device, could be a combination of those, that identify and distinguish the goods of one party from the goods of another. This can also be used to identify and distinguish services from one party to another. Trademarks are generally for goods, and they call trademarks for services service marks. They all fall under the umbrella of trademark, though. Both trademarks and service marks can appear in many different forms. You can have a word, a logo, you can trademark a package design, or even a sound or a color, as long as it is distinctive to your brand. No matter what shape it takes, the trademark or service mark must always identify the actual source of the goods or service. So that is the ultimate function of a trademark, is to identify the source of where these things come from. So some examples would be Nike logo. Everyone's super familiar with that. Nike does have a trademark in just that little swoosh. They also have trademarks with the swoosh and the name. So they've covered their bases on that one. Um, if you guys read this slogan and heard the song in the back of your head like I did, every kiss begins with K. That is a slogan that is also trademarked. And McDonald's, the I'm loving it, that is also a trademark. So this one is an example of a combination of a logo and words that are protected together. So, different types of things that can be protected by trademarks, like we said, it could be the name of a brand or a company. It could be the name of a celebrity, if they have certain services and things like that. It could be a logo or a slogan, even a color. Things that cannot be protected by trademarks are generic terms for products or services, which we'll go over more in a little bit. But think of things like, chocolate or computer or chapstick, things like that. Original works of authorship are not protected by trademark. Those would fall under copyright. And terms that are merely descriptive of the goods or services. So we'll go over that as well, but essentially just something that only describes what the good itself is. So, like we said, a trademark serves to accomplish identifying the source of the good or service. They do this by accomplishing two things. They help avoid consumer confusion about the source and the quality of what you think you're going to get with that good or service. And they help owners and the providers of those goods and services to prevent others from profiting off of their reputation and goodwill. So, perfect example is, imagine you see a soda can with the label Coca-Cola on it. You know, if you buy that and you open it, it's going to be Coca-Cola inside. It's not going to be Pepsi or A&W or any other kind of soft drink. You also know that Coca-Cola was the company that made it and what it's supposed to taste like. Because Coca-Cola owns that trademark, they can prevent others, such as Pepsi or A&W, from taking advantage of their reputation to try and pass off their goods as Coca-Cola's. And in the result would be they're selling inferior goods as Coca-Cola. So Coca-Cola having the trademark allows them to both protect their services or their goods and make sure that no other parties can capitalize off of it. So with trademarks, there are what they call different levels of distinctiveness. So when you select a trademark, it's important to choose one that is distinctive to ensure broad protection. There is a scale that is used when evaluating the distinctiveness of a trademark. The more distinctive the mark is and the more well-known the mark becomes, the wider the scope of protection will be. So generally, there are 5 different categories of trademarks in order of least protection to most protection. The least protected is generic terms. These are common terms for products or services that don't function as trademarks. They essentially describe the product itself rather than its source. So think of things like aspirin, lawnmower, escalator, things like that. Those are just describing the actual good that they are selling rather than indicating the source of where those goods are coming from. The next in this category of trademarks would be descriptive. Descriptive trademarks describe a product or its characteristics. So they can only be protected if they acquire distinctiveness through extensive use. And that's what's called a secondary meaning. So certain things like United Postal Service or American Airlines, those are describing the goods or services that they offer, but they've become so distinctive that the USPTO will allow them to be registered because we now associate those goods and services with that brand. Next up would be suggestive trademarks. Those hint at a product's qualities without directly describing them. So it'll likely require some form of imagination or thought to reach a conclusion as to the nature of the goods. So think of things like Jaguar for a car. That doesn't automatically, when you think of a Jaguar, you probably think of the animal. So it will hint at the product's qualities, meaning, our cars are fast, but it doesn't actually describe the car itself. And it does require a little bit of a leap to get from the word Jaguar to a vehicle. Same thing with Microsoft or Netflix. Those are all examples of things that kind of hint at what they might do, but it takes a little bit of a leap to still get there. Arbitrary is the second to most distinctive. Arbitrary marks use common words that have no obvious connection to the goods or services. So these are distinguished from suggestive because there's no obvious connection. Instead of a little bit of a leap, this takes a lot of a leap to get there. An example would be, Amazon for online shopping or Axe for men's cologne, Canon for a camera. These don't have really any connection between the name and the product itself. So that would be considered arbitrary. The most protected version of a trademark would be a fanciful mark. Fanciful marks are invented words with absolutely no meaning outside of their use as trademarks. These offer the highest level of protection because it shows originality and that these brands came up with something just completely random for their marks, right? Examples would be Pepsi, Polaroid, Rolex, things like that. So time for another pop quiz. Out of the following options, which is the most distinctive and strongest trademark? So A is hot sauce for a new brand of hot sauce. Lawnmowers Are Us for a company that sells lawnmowers. Hot Sauce for a company that sells laptops. Or Clean Water for a water filtration system. We'll give you guys a couple seconds.
You do have a winner. Or like a
Winner.
something that is in the lead. I'll give it a second. Okay. And poll and share results. It was kind of all over the place.
Yeah, so we did have some people think hot sauce for a brand of hot sauce, lawnmowers. Those two would be more descriptive rather than anything else because they just merely describe the product or service that they're selling. Using the name hot sauce for a company that sells laptops, that would be crossing into arbitrary or fanciful because you're not going to automatically make the connection between hot sauce and someone that sells laptops. So the answer is C.
And I think that, we're trying to be clever here. Think about Apple for computer products. It's already been done in the real world.
Yep. So what is the effect of having a trademark? Having a trademark does not mean that you have all outright to use a particular word or phrase and can prevent anyone else in the world from using that word or phrase. It only means that you own the right to how that word or phrase is used in connection with your registered goods and services. So, for example, if you use a logo as a trademark for your small woodworking business, and you can use that to distinguish yourself from others in the woodworking business. If you don't have this registration in another class of services, for example, marketing, you won't be able to stop your neighbor from using a similar logo for their marketing business. Marketing business and woodworking business would be two different types of businesses. And when you register with the USPTO, these would fall in what's called different classes. So the USPTO deals in different classes, and that comes down to what you are offering as your goods or services. So the benefits of registering a trademark, it can help you establish your brand identity. It helps consumers distinguish you from others. It allows you to build an identity and reputation within the industry. Think, same thing with that Coca-Cola example or Apple for laptops. People have come to expect a certain level of quality from those different types of trademarks. So it'll help you protect that reputation by preventing others from selling inferior goods and compromising your reputation. It can also help protect your brand. A trademark protects all of that work that you've poured into your business by deterring others from selling products, capitalizing on that reputation, and what's called goodwill, which is the goodwill that you've created with your consumers. It also reduces enforcement cost. Registering a trademark can reduce the cost of enforcing your ownership because having a registration with the USPTO basically lends legitimacy to your trademark, and it means that it's been established that you are the rightful owner of this mark. So it gives you a ground to stand on if you have to go up against someone in court or something else to prevent infringement. So I will also try to go through this really quick. An overview of the trademark registration process. In order to begin the process, you file an application with the USPTO, which is the United States Patent and Trademark Office. In that application, you'll have to include details such as the mark. If it's a logo, you have to upload the logo, a description of the mark, what goods and services you're going to be selling in connection with that mark. There are usually two different types of applications you can do this through. One is a 1A application, and that is when you are currently using the mark in commerce. So you've already begun selling your goods or services. You can show that you're already using that mark in commerce. Or a 1B application, which is an intent to use, which means you haven't yet started selling your goods or services, but you plan to in the near future. The intent to use trademark application allows you to essentially call dibs on this trademark and you can reserve it for your future use. After the initial application is filed, an examiner will be assigned to your application and they will review it. If everything looks acceptable, they'll move on and the mark will be published for what's called opposition. Opposition is a period where third parties can file what's called an opposition, meaning for some reason they will be damaged by the use of your mark. So this could be, if I filed a mark for Coca-Cola and for some reason the USPTO didn't catch it, then Coca-Cola would file an opposition and say, hey, she can't have this because we already do. So that would be what an opposition is. If there is any issue with the application, you might get issued what's called an office action by the USPTO. Essentially, that's the USPTO saying, hey, there's some form of issue with your application. We need you to correct these things. Once you do that, then you can move forward in the process, or you might have to go down some other routes depending on if the USPTO accepts your response. So once everything is clear and it's published for opposition, if no one opposes your mark within that specified time frame, then your mark will be registered if you filed a 1A. If you filed a 1B application under intent to use, at this point, you will have to provide proof that you've begun to use the mark in commerce, and you do that through what is called a specimen. So you essentially can, submit a photo of your goods or your services. You can do some kind of advertising material or screenshot a website, something like that. And it just shows the USPTO that you're now using the mark in commerce in connection with the goods and services that you applied for. Once you submit that statement of use to the USPTO, then your 1B application will move to registration. And I'm going to hand it over to Nina for the differences.
So that was a lot of information. I want to just kind of walk through the differences because I think that's really going to help tie together everything that was just presented. So let's start with trademarks. So remember, trademarks protect names, slogans, symbols that identify the source of the goods, whereas copyright protects original works of authorship. Think of books, music, film. Why do we file trademarks? To prevent consumer confusion. Okay, we want to protect the brand's reputation and identity. Why do we file copyrights? We want to protect the creative expression of the artist, and make sure that the artist can control their work. How long do these two last? We really didn't touch on that. So a trademark is indefinite as long as it's being used in commerce and as long as you file renewals. A copyright lasts for the author's life plus 70 years. Um, that's for an individual. If it's a publication that's a work for hire, it's 95 years. We already talked about the registration process. Trademarks are filed with the USPTO, copyrights filed with the US Copyright Office. Um, Again, what are the benefits? So trademark, you block other people from using the same name for the same or similar product or service. And it helps to avoid brand dilution. Copyright gives you the ability to stop unauthorized copying, distribution, or adaptation. Sometimes what will happen is we will have a project where it's not only a copyright that we need to file, there's also a trademark. And these are just a few of the examples. So a lot of times a client will come to us with a film or TV show concept. We obviously want to file a copyright application for the script, the music, and the finished audio visual work. So once the movie is done, we file a separate copyright for the completed film. And then a name of a film or TV show that can also be protected. However, it needs to be not just a one-off movie, it needs to be a series. So let's think about a franchise like Star Wars that can be protected by trademark. Books, the text of the book, any illustrations in the book, cover art, protected by copyright. Trademark, Harry Potter, very popular series. You have a trademark because it's multiple books. Video games, so several layers of copyright protection: code, artwork, sound, storyline. And then you also are going to protect the name of the game, if the logo of the studio that produced that video game, and then oftentimes character names, because we've seen with um, shows, movies like what's the lava chicken movie? Minecraft. There's a lot of characters from that are popular now. Steve, my kid was that for Halloween once. Music, song composition, lyrics, recordings. Again, though, Trademark. Why? Because the band that's performing, they also can have a trademark in their name, the logo of the band, and then a lot of artists are actually making a lot of revenue from merchandise. So all of their merchandise is also going to be protected by trademark. So instead of doing a quiz, this time we just want you to take a look at this. It's a screenplay. And if you don't mind, can you drop in the chat which you think this is protected by? Is it copyright or trademark? And we'll give you uh, a minute or so to drop your answer in the chat. Don't be embarrassed. We have a lot of good students here. Well, we have a winner, I think. It's copyright. Yes, a screenplay would be protected by copyright. All right, on to the next one. Let's see what we have. Ooh, this one is a little bit more challenging. We've got um, the song Espresso by Sabrina Carpenter. Um, is this copyright and trademark? Just one? I want a little bit more thought into this one. Oh boy, you guys, it's okay. Even if you get it wrong, it's okay. Interesting. Okay. Um, so yes, there's multiple copyrights. The song is protected by copyright. The photo of Sabrina is also protected by copyright. And then there's a third thing that we haven't considered, which is that she is an artist and is going to be performing this, so she should also file a trademark for her name. And then someone else talked about the lyrics, the melody. Yes, there's multiple copyrights in a musical composition. It's so complicated, copyright and music, that that's probably going to be a webinar in the future. And let's move on to our final so this is a image of the company A24. So anyone who's in the film business probably knows this company. They produced a lot of very popular films such as Twilight, The Florida Project. What is this protected by? I think this was an easy one for you guys. Correct. This is protected by trademark. Thanks for playing all in, guys.
So I think we're moving on to like the last portion of our webinar presentation, which is just Q&A. I think there are a couple questions in our Q&A. And let's see. We have one from Kyrina. I'm sorry if I'm pronouncing your name incorrectly. I hope that's correct. But she had a question. They had a question. Hi, I'm developing a documentary. So I started a company in order to secure fiscal sponsorship. I'm trying to trademark my logo, and not sure what to put in services when I'm not selling services. What are your thoughts for either Nina or Caitlin?
Yeah, that one is a bit of a tough question. So again, because trademarks function to show the source of goods and services, you do have to actually be selling goods and services in connection with the trademark that you apply for. And like we talked about through the process, you do have to show the USPTO at some point that you are using it in commerce, which means it is available for the public to purchase. So as far as services go, obviously it would depend on exactly what services you are rendering, but if you're not rendering services at this time, you may be able to apply for a 1B application. If you aren't going to render services at all, then you may not be able to trademark it.
Oh, thank you. Our next question comes from Gemma. What about procedures or processes that are constantly evolving? I I might need additional clarification on this question, Gemma, if you're still around.
I think
Um,
might be with regard to something that like a system or a process or
yeah.
method, and that is more so the realm of patent law than it is trademark and copyright law, especially if it's like computer code. Sometimes it's protected by copyright.
Mhm.
We do not really work in the technology space, so this is not really something that we come across a lot.
Okay. We have a question from Melanie. Hi, Melanie. So it says, you guys have helped us sort through and get our trademark secured for a musical slash literary work, but we've not done anything about our company name. We now have social media presence on several platforms. When is the best time to consider trademark for the company name slash logo other than yesterday? Smiley face.
Well, I think you hit the nail on the head. As soon as you're using it in commerce on a very public platform, social media, you do want to protect it because you've spent time and money on it, and you want to make sure that people know that, hey, I own this brand. So I would say that anytime you are now out in the public eye, that is when you want to seriously consider filing. And really, I tell people this all the time: the cost to file versus the cost to have to rebrand. It's just a no-brainer. It's a lot cheaper to do things the right way and get that trademark and get that copyright early on.
Mhm. I will also add too, I think there's like a sweet spot when it comes to filing an intent to use trademark because we have clients who file intent to use trademarks like very early on. They're still extending the deadline for like years to come. And we have clients that are like, I'm gonna put this product out in like 2 months. So let's get an intent to use and it will be ready by then. So that there's a sweet spot for when you're still in development of a product or like a service, like you're putting everything together. But yeah, when you've already started using it in commerce and people associate those services with your brand or your company, that's a good time to get a trademark application because you're already using it and you're starting to build your brand, your exposure. And yeah. Cool. Well, I think that's it for all of our questions. Um, Thank you so much for coming, everyone. Thank you for taking the time out of your day. Hopefully, this was an educational lunch break. Um, if anyone has any questions, our information is up on screen. Feel free to take a picture or just use the QR code to go to our website. And yeah, if you have any questions, feel free to reach out. We would love to hear from you. And thank you, everyone. Have a wonderful rest of your day.
Thanks, everyone.
Thanks, guys. Take care.